Buckle up, guys. Today we're diving into a courtroom where poor decisions crash straight into hard consequences. First up, we've got a guy out on bond for driving without a license, who just can't stop driving. The judge is furious, and rightfully so. He doesn't just issue a warning, he practically guarantees the guy a jail cell if he slips again. Next time, bring a toothbrush, he says, and he means it. But wait, chaos levels spike when a woman struts in late, mid-hearing, and drops the F-bomb on the judge. Bad timing? Try worst timing ever. The kicker? There are school kids in the room watching all of this unfold. One handcuff snap later, she's in custody, and the whole room gets a crash course in what not to do in court. It's a double feature of dumb with front row justice.
Look, Mr. Gregory, and I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle.
All right, guys, just when you think the courtroom antics hit their peak, we meet a man who's made the jail his second home. He's been locked up over 30 times and still can't grasp basic legal survival. The judge doesn't even flinch when he says, "I don't know how to get my license." The room practically sighs in disbelief. This isn't just a traffic court, it's a revolving door for the clueless. And when he tries to reason his way out, the judge cuts straight through the nonsense with clinical precision. If this guy's learning curve were any flatter, it'd be a straight line. There's no suspense here, just an ongoing tutorial on what happens when you ignore the law over and over again. Some people just treat court like it's open mic night at a comedy club.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say? What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids and in front of me? Did you just do that? Take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here. Sir, come. Get out of here.
Now we shift to a defendant who comes in looking for mercy but forgets to bring accountability. He's caught driving without a license and tries explaining it away with a tangled web of excuses. The judge, however, isn't buying any of it. She flips through his record like a receipt roll at CVS, and it's long. You can see the tension rising as the defendant keeps interrupting and stammering through half-truths. She reminds him, this isn't her first rodeo. The court isn't interested in sob stories, only facts. And the facts scream, you've been here before. The warning is clear. He's skating on thin legal ice, and the judge is about done handing out second chances. You don't walk into court with dirty hands and expect a clean slate.
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, your Mr. Perkman Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Paravine Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, name for the record, please.
Bradley Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably. And at this time, I would ask to be allowed to recuse myself from this case, Judge.
Here comes a sovereign citizen who thinks YouTube Law School is a substitute for actual law. He refuses to give his name, claims the court has no jurisdiction, and proceeds to spout sovereign gibberish like he's casting spells. The judge stays impressively calm, but you can see she's heard this script before. The courtroom gets an impromptu seminar in nonsense legalese, and everyone's patience runs out fast. The man is clearly under the impression that saying, "I do not consent," is a legal force field. Spoiler, it's not. What he ends up doing is handing the judge exactly what she needs, grounds to issue a warrant. Watching this unfold is like witnessing someone argue with gravity. The court may be patient, but it's not stupid.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case, is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today, asking for this court.
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's, yes, you can certainly request a transcript. You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom.
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It was
just on transcript.
Recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request the transcripts.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Also, I have a request on the Michigan Courtroom 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to terminate representation specifically as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course. I would ensure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. You filed something on January 17th, and you're requesting our 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at City of Woodhaven Public Schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on me, specifically told them, case dismissed, that he cannot violate my constitutional rights.
Now it's a mother-son courtroom tag team, but not in the way you'd hope. The mother steps up first, making wild claims and refusing to comply with even the simplest court decorum. She argues, interrupts, and insists she's being targeted. The judge tries briefly to explain the process, but the woman's on her own monologue. Then her son enters with equal defiance, like he's prepping for a sequel. The court quickly realizes this isn't just dysfunction, it's generational nonsense. The judge doesn't waste time, she shuts it down fast. What we see here is a family committed to being wrong louder, not smarter. And that never ends well in front of a judge with a calendar full of real cases.
And I think that's the issue.
Oh, hold on, please, just one moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with you.
The allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
No, you need to read the whole thing, other than just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do. I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again.
Next up is a defendant who doesn't just dig a hole, he brings a backhoe. He begins by blaming the court clerk, then accuses the judge of misconduct, and finally claims the entire case is void because he doesn't agree with it. The courtroom is stunned by the audacity. The judge gives him room to speak, hoping logic will land, but it never does. Instead, the man gets bolder, louder, and more ridiculous. It's like watching a legal self-destruction in slow motion. By the end, the judge has heard enough and reminds him that defiance isn't a defense, it's a ticket to jail. This is courtroom suicide by arrogance, and the only thing more tragic is that he thinks he's winning.
If I followed your white laws, I follow them, and then you stomp on me when I followed your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys
stop
sit
right now,
dogs
stop
on.
right now.
You
I'm
violate
not
our
100 years
rights.
old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay, yeah, it don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest. But
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim. I'm the
Which this
victim.
court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse and it was okay. You should have arrested me then. When I go to your
So
schools
I don't
and
have
you're wind
arrest
out,
powers.
when I go to schools and you're wind out, you should arrest me.
We wrap up with one final gem, a defendant so deep in denial, He's practically subterranean. He refuses to recognize the court's authority, refuses to enter a plea, and demands to leave on his own terms. The judge calmly explains the process, but he counters with sovereign soundbites and fantasy law. Eventually, she's forced to do what every judge dreads, shut him down with hard legal facts and a direct order. He walks out still thinking he won something, but the rest of us know better. This final segment is the cherry on top of a cake baked in delusion. And that's it for this legal circus. If you enjoyed watching these courtroom catastrophes, make sure to like the video, subscribe to the channel, and we'll see you in the next one.
Just to clarify, I as a judge do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've been through your system before.
So
also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment, please. This court, sir, has to take the allegations, and there's a process.
Like I don't know it. I know your process. I've been down your roads before. But
I don't know
I'm 15.
what roads of mine you've been down, sir.
I'm 15.
But you've been here, excuse me, you've been here in this court a number of times,
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you even stated that yourself.
That's not all entirely true.
Hold on, sir, I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir, I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postponed. The City of Woodhaven
the
wrote
federal
violation. No, they wrote violations on me for posted signs in this case. In other cases. Because I was protesting in the city of Woodhaven.
Okay.
But on that, the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now.
You.
I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year.
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're sleepy or stupid.